Alright, so this is just We the People news. I'm doing this video without prejudice and without recourse. Alright. I'm not waiving any of my rights whatsoever in the whole wide world. Alright, I'm keeping them all. This video is I'm so offended. Alright. I kind of like this one because what he's doing, and generally, and I have not once go through his whole website channel. I just like what he did on this one. So feel free to kind of check through his video. Alright, this is going to be a little bit of a long one, but you know, he's not giving consent. And if you probably listening here and all that, they may say something that he's not volunteering in this. I may be wrong, but I've told previous, everything has to do with consent, but you always got to challenge it, because what they're trying to do is trick you into consent, and they keep threatening into consent, and everybody gets scared and falls through in consent. Okay, giving consent. On my last video, I'll remind you guys on this video because I didn't say it on the other one. Alright? Anytime you get an attorney, you are waiving your rights. So, I'm not saying don't get an attorney. If you need one, get one. I'm just saying that, you know, if you get one, you're waiving your rights. You do not have any rights. And that's exactly what they don't want, because they're trying to violate your rights anyway. Period. But if you give consent and enter the contract, well, you waive your rights either way it went. Alright? The only way you want to do this is remotely doing this is if both parties is equal footing and you agree to the contract. Alright? Let's go ahead and get this one started, because it's going to be a while. And dare I say it, I'm probably not going to be in here on this video. So, look on the bright side. I'm not going to be cutting in and out, y'all. Anyway, let's proceed forward.
Alright, so this is an explanation for the March 31st, 2021 contempt court hearing. As you saw in the last video, that was the first hearing, and after the fake judge said that I was found in contempt, and then he made his contract offer. However, at the very beginning, they stated what my status was and what I was there for, procedurally, what was going on. So go check out that video first before we get into this one, because they go in order. So that's the December 14th hearing, and then this was the next hearing. Prior to this hearing, I filed an affidavit of notice of demand. I told them they committed process violations, and I filed a special appearance, and here we are. I'm the accused. By the way, when the AG introduced himself, he also said, I'm here for representing the Attorney General for Child Support Services. Not representing the mom, not representing the child, you're representing the state. That's their interest. It's the state's money. And then I responded when they asked who was on the line. First thing I said was, I'm the accused. That's who I am in my paperwork. I'm not their obligor. I'm not petitioner. I'm not their all caps name. I'm none of that. I have the right to determine and declare my status, and I keep it consistent in my paperwork and in my oral hearings. I am who I declare myself to be, and I declare myself to be the accused, not the title that they give me.
Okay. Mr. Quintero? Quintero? Is that?
I'm the accused, allegedly, allegedly.
Okay, thank you.
Welcome.
Okay. Yeah, I'm gonna go ahead and call the case, and then I know there's some issues you to talk about, so go ahead, for the record. This is case SP 2017-0042. Present on the phone is the petitioner and the respondent, as well as the state attorney general. Alright. So I see, this is the first step of our review hearing, so I see that a motion to continue with file.
That's right. I filed a motion to continue because I was in the middle of a lawsuit against the fake judge in the previous hearing. So in the previous hearing, the December 14th hearing, I actually filed a lawsuit against that judge, that fake judge. That fake judge is not on these proceedings. This is another fake judge. And I filed a motion to continue, stating that I wanted to concentrate my efforts on that lawsuit, not in dealing with this matter that has nothing to do with me. And procedurally, when you file a motion to continue, procedurally that goes first, which is why that was addressed first before we got into everything else. However, there's no rules here, and they just do whatever they want to do. You'll see. Yeah.
I'm going to ask our attorney general to give me a brief update, and then we'll talk about the motion that was filed, okay?
She had no need or reason to ask him for anything, right? That's because it's the AG that's filing the lawsuit, which is what a contempt hearing is. It's a lawsuit. They file a lawsuit to get the money that they're not getting. So they want to hear from him because they're the moving party in a lawsuit to try to get money for their state debt. That's why she wants to talk to him first, even though procedurally, first I put in that motion to continue. So they should always go with whoever is moving the court. Whoever's moving the court always goes first. Now, they're going with him because of the lawsuit, but I put in the motion to continue. So, I don't know, I guess she talks to him. It could have gone either way. So this isn't entirely out of procedure because they're the moving party for their debt. I'm the moving party for the motion to continue. I filed it and it needed a response. There was no response yet. So I guess procedurally, we're still kind of okay just for this particular moment right now and what's occurring right now.
Thank you, Your Honor. Since our first hearing, we have received through unemployment benefits. We have not received any wage or payments. Okay.
Well, we went into his
And what was the date of the last hearing?
their debt. That's what they went into.
December 14th, okay.
So they disregarded the motion I put in first. So yes, it is incorrect. They addressed the motion first.
Sorry, we're having some technology issues
We're having some procedural
getting access
issues.
to the file today.
Right.
Alright. Okay, I've got that one up. Alright, and petitioner, you filed a motion to continue?
For the record, I reserve all my rights. I am present by special appearance and pro deal proceedings. persona as the accused. And there was a motion to continue that was filed, and the process of service was satisfied as there was a affidavit of certificate of service that was filed proving that service was satisfied. Of said motion to continue.
She said petitioner, right? I didn't answer as petitioner. First thing I said was I declared my status and I reserved my rights. I reserved my rights and then I declared my status. Okay?
Right, and what is the basis for your request for continuance?
It's listed in the document. I'm not here
Do you
to
have anything to add?
it's very specific. This matter is tainted and it should have been dismissed a long time ago. So I require a written response on the record, and I shall take a continuance until I receive a written response on the record or my acquiescence without a response.
I'm not there to argue. Okay? She asked me about my paperwork. I'm not there to read the paperwork. If you have questions, read the paperwork. Okay? I'm not there to argue. Okay? In my document. Look at my paperwork. And, you know, due process violations. This matter's over. That's all I'm there for. Just a resolution.
Okay, is that,
Oh, and as far as how acquiescence, you know, they all understood what I was talking about. You know, I moved the court, and if they don't respond, then that is, you know, you basically get what you asked for by acquiescence, basically. You know, if you don't rebut, you must rebut everything. That's what we always say, rebut everything. You always rebut, because if not, then you default. So I told him, I'm having a motion to continue. You know, if you fail to respond, then I'm having it by acquiescence. I'm not asking. I am telling them. Okay, that's what you need to do. You need to tell them what to do.
do either of the parties object to the continuance? I object. All right, and I want to hear from both of you. So respondent, go ahead. This original, I object because this original child support order was not established under the Title IV. Mr. Quintero was the petitioner in this whole matter,
This is for
and he
me,
has 4 years of litigation in this matter. And he has several times tried to get the child support order dismissed. And when all of this failed, now he is going on to this new constitutional rights being violated, where originally for 4 years, no rights were violated. Mr. Quintero wanted the court to decide his custody and his child support matter for him, in which they did, and he was unhappy with it. So now here we are with him trying to still continue to get out of paying his child support. He has never made any voluntary payments. And they've all been intercepted payments from the child support office because it was not, he had made it clear in our original custody case and everything that he has no intention of paying child support for this child. He does have an
I
education
asked her
that
about the
he's
continuance.
and has no problem paying child support for. So I object because this matter has been heard for 4 years, Your Honor, and it needs to just come to an end so we can move forward.
All she needed to say was the last sentence.
And I believe I heard our the Attorney General. Yes, sir. Mr. Quintero declared accusations against
Irrelevant.
the 18 declarations made. So the motion to continue is now pending. The security guard at the hospital hangout takes patients.
Okay. Having heard from all the parties and considered the full investigation, I'm going to deny the motion to continue.
Back out, Adam.
It's unimportant to me. It's unimportant to me.
And you furnished with a, brief summary. Do you have any recommendations for how to proceed today, sir?
I would like to ask Mr. Montero to step in. All right, now we're going to Mr. Swirly. His participation. Thanks for listening to your
Okay, let's have the parties sworn in. Will please raise your hand and raise your right hand, please.
Excuse me, I'm not interested in that. I require a written response on the record for the motion to continue. I have been lied to before at these meetings. I believe I am being lied to now. I require a written response on the record.
Will receive a copy of this minute entry denying the motion to continue. A written copy of it in the mail.
Then
In
my,
the meantime, please stand and raise your right hand to be sworn. Do you and each of you solemnly swear or affirm to speak the truth, the whole truth, and nothing but the truth, so help you God?
All right, now we're going to Mr. Swirly Nacra.
I'm not interested in these proceedings. I'm only here so this matter can be dismissed with prejudice or write an order I can appeal so I can file lawsuits. There you go. There you go.
Okay, so I don't have a motion to dismiss in front of me. I had a motion to continue. Right now, we're here for a review hearing, and unfortunately, that is all I can do. That's all I have the authority to do in this case.
There is
To proceed with the review hearing.
There's an affidavit of notice
All
and
right,
demand
now we're going
with
to Mr.
a order for dismissal
Swirly Nacra, excuse me.
that was
Thanks to the approval.
refused by the clerks who are not allowed to do so, but that should have been sent to you. An affidavit of notice and demand along with an order for dismissal.
Okay, well, today we're here on a review hearing and a motion to continue.
I am here so this matter
At
can be
this point, I've
dismissed.
denied the motion to continue, and we will proceed with the review hearing. If you have other legal actions that are proceeding in this matter, those remedies can be taken up at that time. This is the time set for the review hearing. So please answer the, stand and be sworn.
She said, please.
I need a response.
I'm not interested in any of that. I'm only here so this matter can be dismissed with prejudice. You can write an order I can appeal, or so I can file my lawsuits.
Are you refusing to answer questions?
I appreciate the questions, but I'm not interested in them. I do not consent to these proceedings. I do not consent to being the surety of these proceedings. I demand that the bonds be brought forth so I can see who will identify me, because I'm a man who's damaged in this matter.
Okay, well, unfortunately, that's not the matter in front of me today. Today, the matter in front of me is a review hearing. And what we are trying to determine is whether or not you have complied with the prior orders regarding obtaining a job and proceeding with providing the court with information regarding your attempt to find work. That is the only issue in front of me today and the only issue I'm able to hear. So, at this point, the Attorney General needs to ask you some questions. And you may, once you're sworn in, you may object to the answers or object to the questions that you're asked if you have valid and evidentiary objections to them.
Once you submit to the jurisdiction, then you can further incriminate yourself or incriminate yourself even further. That is what she basically said. They're allowed to lie.
So we're here on a review hearing today. This isn't a motion to dismiss or anything else.
I'm
Are
only
you
here.
still there?
I am only here so this matter can be dismissed with prejudice, so you can write an order I can appeal, so I can file my lawsuits.
That's it. That's
I
it.
cannot do anything until you have been sworn in. So can you,
I cannot do anything until you have been sworn in.
Did you hear that? Let's hear that again.
Or it can be dismissed with prejudice, or you can write an order I can appeal, so I can file my lawsuits.
I cannot do anything until you have been sworn in. So can you please answer the clerk regarding the question she asked?
She said, please.
I appreciate the question. I'm not trying to be disrespectful at all. I'm just not interested. I do not
Okay,
consent.
and you can make your objection once the questions are asked. If you, right now, can you please just let the clerk swear you in so we can finish the hearing?
4 times she said,
I
please.
appreciate the question. I am not interested. I do not consent to these proceedings.
Okay. Alright, I am going to,
Who is in charge of this hearing right now? Think about it. Who is in charge of this hearing right now? Because from what I heard, that big judge said please 4 times. If somebody is saying please, they are not in charge. They're asking somebody to do something because they don't have the power to do anything. She said please 4 times. Who is in charge of this hearing right now? It's not that big judge.
Should be rising. This should be rising.
make a record that the petitioner has refused to board and is refusing to answer questions. Sir, and I'm sorry, Mr. Attorney General, I did not catch your name at the beginning. Thank you. Can you, is there a record you would like to make at this point?
Acknowledges.
Do you have any recommendations for the court meeting at this time?
Look at the smile on my face. Did you see it? Did you see it right there? Look, 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 look. There's no finding of fact. Sorry.
Ms. Hadley, do you have anything you would like to add? Any questions from the court at this time? I'm just curious.
All right,
Another
that's it.
review hearing with
Yeah, yeah.
you and the circumstances of the executive petition was
We got a nice
harassed
little
me
gal.
for 4 years.
Shrimp.
And I need another court date for something that he makes clear that he is not going to abide to. Only burden me.
We got some contract agreements, some
I
papers, what good is down
understand
here.
that,
We're gonna whip those
and I
in.
am very
Then you got the
frustrated.
little that's an ingredient from the old
I
one. Yes.
understand that,
That's just right.
and unfortunately, the remedies available to the court at this point in time do not include finding incarceration for contempt based on the pandemic, because of the pandemic.
Liar! 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 Liar!
We'll rub the booty. Remember that was
Oh
what
my
was me.
God!
situation because of the pandemic. Liar, 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 liar. They couldn't do anything. They had no finding of fact. There was no proof of illegality. There was nothing. They couldn't do anything. Anything.
At this point, a review hearing is pretty much our only option.
Yeah.
What I am going to do is I will have a review hearing. Give me a second, however. Alright, the court finds as follows, that the court has continuing jurisdiction in this matter, that there's a current child support obligation specific to the child support order that was issued on July 31st, 2017. That child support order is a valid order, and that petitioner does in fact have notice of said child support order. I'm going to reaffirm the prior orders. That petitioner shall report any employment that he obtains between now and the next review hearing to the Division of Child Support Services within 2 weeks of obtaining employment. I'm affirming the prior order that petitioner shall apply for a minimum of 3 jobs each between now and the review hearing. And affirming the prior order that petitioner shall report to Arizona at work or Pima County One Stop to obtain any additional guidance or services in connection with his job search. I'm going to set a review hearing. For June 8th. I'm sorry, make that June 3rd. At 3 p.m. 30 minutes.
Imagine reading for later. You'll fire
At which time any additional matters will be addressed.
These things are amazing. You'll text us
Separate order will be issued with the call-in information for the review hearing. Further admonishes the petitioner that a failure to secure any future hearings without good cause may result in the court making a finding of contempt for failure to appear, and a child support warrant may issue.
Oh, it's your friends again. Oh, shit. Oh, shit. Scared me. Grabbing me.
I just need fish.
If there's nothing further, I think we can stand adjourned.
So you go.
Thank you, everyone. Thank you.
I just need fish.
So keep it quiet. Well, I spoke with more confidence during this one. As you can see there on the screen, I have my script. A lot of that was just the same thing, but that was it. This was shut down. The actual video itself is 38 seconds, 17 minutes, 38 seconds. Shut down in less than 18 minutes. Stayed in my square. Didn't let them trick me. You know, I was in charge of this hearing. Okay, in case you didn't realize, I was in charge of this hearing. It's irrelevant that they denied the motion because they just pushed everything out anyway. Another review hearing a couple months later. It's irrelevant. Okay, so I'm gonna show you the next video how I conquered that as well. But please like, share, and subscribe to the channel. If you need help with coaching or you know, just want to talk to me about what you have going on. I'm not saying I know a lot, but I know enough to get to where I've got. And yeah, so you know, please support me. And the channel is I'm So Offended with 3 O's after S. I'm So Offended. And you know, hit me with a donation or a gift if you can, so that way I can continue to do the research and put out these videos, these raw videos straight from, you know, the source, the actual court hearings, the actual mouth of the Attorney General from the Child Support Office. I get it directly from them. I'll be putting up more videos and also conversations with the clerk of the courts, what it is they do. But anyways, thanks for the support, and also, as always, shout out to Chris from Child Support Made Simple, who helped me with my paperwork and coached me. Bye. Peace, y'all.
All right. Well, this is Diesel We the People News. Like I always say, you know, never look just straight forward. Always look around you. Be able to protect yourself and your family by any means necessary, y'all. Alright, as you can tell through my videos, I don't just stick to one. There's options out there. What is the best benefit for you? Just because something may be good for me, don't mean it's good for you. If something good for you, don't mean it's good for somebody else. So we always got to keep an eye open. And the one thing that was guaranteed, insane people, crazy people, keep doing the same thing over and over and expecting different results. We've been playing their stupid games for years, y'all. And we keep going in that courtroom expecting something different. Alright? It's time to step out of the box and settle the matter on your own and quit depending on wink wink different people, right? Attorneys and all that. Not saying don't get an attorney. I'm not an attorney. It's just my opinion. If they work for the state, they work for the courts, and they're not benefiting you, then it just makes you crazy to expect they're going to keep working for you when they don't. This has been going on for years and years. It's no secret. Especially on my videos, you know how I feel about them, y'all. Once again, the Bible of Jesus said, you know, woe to your attorneys. You have the key to heaven, and keep it for yourself, right? They know the trickery words they're using, and they're not letting you access their knowledge. So they're keeping you at bay, is basically what they're saying. And that's what Jesus is saying. The attorneys know the law, but they're tricking you, and they're not sharing their knowledge, which keeps you in slavery and bound with ball and chains to them. You know, our Congress members now is attorney general, or attorneys. You know, then we got senators, are attorneys. You know, judges are attorneys. You know, we're so surrounded by attorneys. And then when you go talk to your local officials, oh, well, I'm going to have to ask the attorney. Or you're going to have to ask our attorney. You know, everything has to do with attorneys. Sit and think about it, y'all. They got our government under ball and chains. They got you under ball and chains. And they got our government officials under ball and chains. Even our sheriffs. That's supposed to be arresting these people. Diesel We the People News. Bye, y'all.